If you have a phone, you're going to be in trouble if all goes well. If you have a computer, you're even going to be in more trouble if all goes well with the amendments. But this year in February, we did have Kampala Central MP Muhammad Nsereko seeking leave of Parliament to introduce a private member's computer misuse amendment bill, arguing that since the enactment of the Computers Misuse Act in 2011, which is pretty much about 11 years down the road, the bill seeks to enhance provisions on unauthorized access to information or data in the Act of 2011, and therefore we do have experts on this conversation that are going to actually streamline for us exactly what it could be and the implications of that on you and me, who just go about posting things on social media without caring what the implications of them could be. I'm joined by Allan Ssempala, who is a human rights activist. Good morning to you, Allan.
Good morning.
You're most welcome.
Thank you.
Okay, and I'm also joined by Counsel George Musisi here to speak to us on this contentious issue. Counsel, I'll start with you. The bill has been argued in the public eye, and it's 11 years down the road pretty much since the 2011 Act. Now we want to find out from you, is this amendment timely, especially at a time as this or in this moment?
The amendment is certainly brought in bad faith. Usually an amendment is made when you are seeking to cure defects in an existing law. Like you've rightly mentioned, we've had that act for over 10 years now. The act, all its problems notwithstanding, has not had any, I think there's only one person who has been convicted under that act, and that is Dr. Stella Nyaz, whose conviction was later overturned by the High Court. And we've had several people, a particular category of people, being charged many times for offensive communication under that act. And there are people who would think that the charging or the prosecution of those people has been quite selective. Now, even the principal act that they're seeking to amend, we have problems with it. As lawyers, we even dragged it to the Constitutional Court. The Constitutional Court is yet to make its pronouncement on the constitutionality of that act. Now, if you seek to bring an amendment, like I've mentioned, you bring an amendment to cure defects. What are the defects that the honorable member is trying to cure? Instead, despite the fact that they have failed to prosecute anyone successfully, and all its problems we're having with it, like muzzling free speech, of muzzling freedom of the press, is now instead bringing even more draconian measures. And like you've rightly mentioned, everyone has reason to worry. Every person uses a smartphone, every person uses a computer, and the whole intention, the whole effect of these proposed amendments is certainly to muzzle any form of free speech and ultimately even the freedom of the press, because anything which fetters with the free movement of information certainly will affect everyone. Okay, all right. Allan, do you agree that movement of information or expression, therefore, will be hindered with these amendments?
Certainly, but also to add on what Counsel has mentioned, you see, when I looked at the amendment bill, it's not bringing anything new. Already his proposals are catered for by the already existing other laws. We have the Data Protection and Privacy Act, which actually regulates the use of personal information. When you look at his amendment, the proposals he's bringing, specifically the amendment of Section 12 of the Principal Act, the insertion of Section 22, 23, 24, then later on 27, all these are catered for. Okay, so what the Honourable is bringing already is catered for by the Data Protection and Privacy Act. When he talks of information that pertains children, the use of information, already Section 8 of the Data Protection and Privacy Act regulates the use of information. You have to seek personal, you have to seek consent from a parent or a guardian. So for me, when I looked at the bill, I think the most interesting thing we should address ourselves to, and why they're actually bringing it, is to suppress one sector of the citizenry. You know, any good law should be really...
Which sector is that?
The politicians, especially opposition. When you look at the proposed insertion of Section 27, they are proposing an insertion, 27A, where they are saying if you are convicted under the Act, you can't be allowed to stand for any public office.
For 10 years.
Exactly, for 10 years. And if you are a leader, if you're found to be a leader, then you
vacate office.
You vacate office. And you see, the same amendment only defines a leader according to the Leadership Code. Now, the Leadership Code Act defines a leader to be a political head, a politician, or one who heads an MDA or a any other government department. And in political leaders, of course, there are political party leaders and members of parliament. And if you notice, it has been, I think, Honorable Kyagulanyi, who has used social media so well that he has mobilized even the youth. And he has been calling the president a dictator. Already, like he mentioned, the current law in its own state is problematic, specifically Section 25, that speaks of offensive communication. Many people have been charged under that section. So for us, we are thinking, if there is anything to be amended, it should be that section. Of course, even 24 and 26 are problematic, but specifically 25. When does offensive communication begin? And when does it end? When you start regulating how we are supposed to speak, then you're going to start regulating how we are supposed to yawn and dance. Because in any democratic dispensation, there ought to be that free flow of information. It should be a marketplace of ideas where we exchange. It's the only way we can engage in the governance of our country. Look here, meaningful debates have been halted. Political parties are not allowed to go and mobilize and have serious debates. The only avenue people have had is the social media platforms to vent out their dissatisfaction, to hold their leaders accountable. If holding you accountable offends you, like Section 25 says, then many people are going to be convicted using the same act. So if you put that clause, the last clause, actually the last proposal of section insertion section 27A, that's the most problematic. The others we can actually, like I mentioned, we already have a law providing for that. Amendment of section 12 of the Principal Act, the other insertions, they're already catered for in the Data Protection and Privacy Act. I think the interest is in the insertion of section 27A, which will prohibit people to run for public offices. And who has been using social media? Mostly opposition. So using that section alone, many people will be barred from running for political offices, and those who are already holding public offices will be, you know. So I think the law in its own, the amendment, it's in bad faith. And look at the person bringing the amendment, the Honorable. He's been one of those who have really used social media in a manner so wanton. He has abused people, all manners of words, all sorts of words. He has called them bigots. He has called them hooligans. And by the way, my appeal to Parliament, or parliamentarians, we should trash that amendment. If we are not amending Section 25, to save Honorable Nssereko from his own bill, and most importantly, to save Ugandans,
before it eats him.
Exactly.
Okay, all right, let's focus on Section 25, offensive communication. According to my small computer here, in summary, to prove offensive communication, the prosecution must show the following. The communication was willfully or stubbornly sent to the complaining person. Then the communication was sent repeatedly to the complainant. Now, the communication has no legitimate purpose. That is the definition of offensive communication. So there's got to be a pattern of repetition for it to actually then stem and considered as offensive. What do you make of this offensive communication? What is it? Where does it start from? Where does it end?
Any law which seeks to be subjective ceases to be a good law. What makes offensive communication offensive is in the how the other person, the complainant, feels about how you've communicated. If you send me meetings, invitations to wedding meetings repeatedly, and I'm offended, then you are guilty of offensive communication. So if the law is subjective to the whims of the person who's feeling it. Now, like I've told you, we even have petitions in the Constitutional Court challenging
so
that.
Saying that it's based on feelings?
It's based on the feelings.
How do you
now,
determine the feelings?
Honorable Nsereko, who is supposed to be a lawyer, is taking it even further by saying, one, if a person makes demeaning statements, if a person makes malicious statements against the person, if a person makes false statements against the person. Now, why I'm saying that Honorable Nsereko ought to know better is because every first-year law student knows of a case in Uganda from a court not less than the Supreme Court, which said spreading false news is not offensive. In a marketplace of ideas, like Allan has mentioned, free flow of information is the cornerstone of, in fact, even for politicians. Politicians go to their voters. Their voters are right to criticize them. Their voters are right to even insult them sometimes. Because what amounts to an insult may not amount to an insult to you or to me.
That's true.
So if you make it subjective that this is what is demeaning, what is ridiculing, for instance. So the curtailing, we all know that freedom of expression and freedom of the press is not unlimited. But the curtailing of that freedom should be, one, either in public interest or in what is fair and justifiable in a democratic society, like Uganda aspires to be. So if you are, first of all, Nsereko knows that you cannot even make a legislation to overturn a court decision like he's trying to do, because spreading false news, court has already said it's not offensive. Two, there are always civil remedies you can seek. If I feel that Allan has insulted me, instead of wasting the state resources of prosecuting him through the courts, I can always go to the civil courts, drag him to court, and he's ordered to pay damages. So if you feel that you've been demeaned and defamed, there are always civil remedies.
Solution to that.
Yes.
Okay. All right. That's very interesting. Now, let's talk about the umbrella upon which he's hiding. The protection of the children. You're the human rights activist, Allan. Why is he hiding under this umbrella particularly?
No, I think all those are known to them, an issue like I mentioned earlier, because already the Data Protection and Privacy Act provides for that. If you have to use personal information of a child, you ought to seek permission from the parent. I think the intention of this amendment bill is dealing with political opposition parties precisely, and we should pay attention to the last insertion of Section 27A. Definitely, no one should use information regarding a person who we call a data subject without their consent. You ought to seek consent and permission to process that information. If it's for a child, then you seek from a parent. We agree with that. But the problem we have with the Data Protection and Privacy Act, it's not as punitive as ought to be. For instance, if you are convicted under that act, I think you only have to pay 4.8 million. I mean, people who use personal information for data subjects have that money. Data mining is a big and rich industry. So they can put aside that 4.8 and use. So I think the Data Protection and Privacy Act ought to be made more stringent. It is reasonable. But when you are now putting such stringent measures on freedom of expression, an act that actually is meant to deal with free speech and free flow of information, then we have a big problem. We are actually getting from a bad situation to a worse situation. So maybe also to add on what the issue of who determines what is right. there is an artist, I think he's called Omulangira Suna. I think a certain TV presenter demeaned him. And
oh, yes.
Yeah, he used the law, and we saw it working. So if I've demeaned you, you have all avenues of the law to take me to court and prove that I did demean you. No man, no community, not even government, have the infinite wisdom to determine what is true or false. You don't have it. What I find normal, you find it demeaning and offensive. I mean, I'm a Muganda. If I tell you Tom Manyira, it's cautionary. Don't cross the line. Someone who is a non-Muganda, they will find that offensive. You get it? So we are a multi-tribal country. Okay. Anything can be deemed demeaning or defaming, or so really, in a democratic dispensation, the hallmark for any democracy is the ability to express yourself. And the intention of protecting the freedom of expression should actually even benefit those who have ideas and opinions that are not favorable.
Yeah.
Today, for instance, Honorable Ssempala, he was a beneficiary of that freedom of expression when he was first rising star politician at a relatively young age. He stepped on many toes. I'm sure he spoke many words that didn't go well with a certain sector of people. They didn't use it. Now that he's running out of favor, he's realizing that, wait a minute, they're abusing me. The moment you run out of favor, you start looking at criticism as abuse and demeaning. I think Honorable Ssempala should give a benefit to citizens to enjoy the same rights and privileges he enjoyed while raising up.
Okay, all right. I want to find out from you, Council. You talked about defects, that the Principal Act already has a lot of loopholes. Could you please stipulate for us what those loopholes are and what could be the cures instead of these amendments that Honorable is bringing to table? Yes,
first of all, just a quick one. The rider is riding on the issue of children is even catered for as well in the Principal Act on child pornography. There's a provision on child pornography. I'm yet to know if any person has been convicted of, because when you bring a law, you should know that maybe we've seen so many convictions, but maybe the punishments are not as stringent. The main problems we have with the Principal Act are the two provisions. Allan talked about them briefly. Section 25 and 25. One talks about cyberbullying. And then 25 talks about offensive communication. And we have a problem with offensive communication because we believe the ingredients of that offensive communication and the way it has been used to curtail the freedom of information to move freely, and then the freedom of the press as well. What have we seen? You can look at the cases where police has used that. And like I've mentioned, there are not even so many convictions, but it's always deliberate. It's always looking out for the criticism. And like we say, that we should not criminalize what would be civil remedies. We should not criminalize personal grievances. Like you mentioned earlier, when the Honorable, the mover of the bill, was talking about go to leave of Parliament, he was coming on the backdrop of venting with a lot of social media fans, and said that, in fact, I'm going to bring a bill to amend this and make it more punitive. So I think a legislator, and it's my plea to all the legislators, we should not legislate out of emotions. We cannot criminalize anger, that because I have the power to make laws and someone has abused me, let me make it criminal to be abused. Politicians, the politicians world over, the foundation is free, is exchange of ideas, and as those ideas are exchanged, certainly you will hear some which are not favorable to you, which are not palatable to you. So the moment you start legislating and you're saying that because I was insulted, let us as MPs ring fence this provision of insulting, you would be taking us to North Korea. So the Principal Act has problems because the definition of offensive communication has been used to against what Article 29 of the Constitution says, that every person has freedom of speech, every person has, people have freedom to practice their journalism or freedom of press. And whereas those rights are not absolute, the curtailing provision in the Constitution says that if you are curtailing, any exception must meet the internationally acceptable standards of a democratic society. In Uganda, we have received the Supreme Court interpretation of what amounts to that. And false news, being ridiculed, being demeaned, like Honorable Ssempala was saying, are not among them. So we have problems with the Principal Act and certainly the amendment. So I believe the amendment is done in bad faith. And I'm calling upon members of Parliament to throw it out with the contempt it deserves.
You can't say that because the Speaker of Parliament, who has also recently suffered offensive communication, has allowed it to go to the Ministry of ICT and Information and get some research from the public and then come back with the response before anything goes out of hand. Now, if that is already you know, an opportunity or a window there for it to actually be amended, the actual bill to be amended in that direction. Let's look at the punishments. Don't we feel the punishments are a bit too harsh? For example, for a leader, in this case a political leader, holding office, you have to leave office if you are found guilty. And then you look at the other punishments that you're looking at. If someone is found offensive, they're not yet in a leadership position, as you know, described politically, they can't express any form of interest for the next 10 years. And then there's the punishment of the 7 to 10 years imprisonment, or an equivalent of 15 million shillings. Isn't that a bit too extreme?
For freedom of expression, definitely it's a bit extreme. It's really extreme, and it's draconian, really. Like we've mentioned, I mean, the law has come to deal with political leaders, and rightly put in his proposals in the amendment, he's looking at leaders who are defined in the Leadership Code Act. Okay, does he want to tell us that the only people who can do offensive communication, who can demean people on social media, are those that as defined in the Leadership Code Act? Where does it leave us? If I demean you, I can go away with it. It's only those. Already the law is selective. It is selective. Even in its current state has been selective. If you notice that only those that have been attacking those with power,
the Kakwenza
have been prosecuted under the law. Yeah, Kakwenza attacked the first son. Dr. Salanyanzi talked about the president and the wife, and those are the only people. You get it? So a person who doesn't wield power or influence can't use the act. Has been selective. Yeah. The normal people have been demeaned. Okay, they have been demeaned. I mean, there is cyber stalking. There is, but the police also is not capacitated to do that. They don't have forensic materials. They don't have forensic experience to investigate these. As unwanted witness, we did a report on online violence against girls and women. Many girls were being stalked, and their private, you know, information such as images were being used on social media, which was really against their consent and their dignity. So when we did a research,
ironically, the police will actually pay more attention to the person who has been offended.
Exactly. So
yeah.
What we realized, what we obtained from that report is that police would tell victims to go and look for those who have offended them. You get it? Now imagine you're on social media, a random person offends you and you don't know where to find them. So they're not capacitated to do that. But also you look at the attitude of police, when you look at their reports for the last years, the only cyber crimes they report are those that involve money. So they don't know about the violence that happens, especially to the girl child. So there is need to give capacity to CID, and I think they have only one cyber unit, which is at Naguru, which is almost dysfunctional. It only comes out if a big person is attacked. So this law is in bad faith, and honestly, we honestly appeal to the politicians and especially the parliamentarians to deal with it with the contempt it deserves. And we request Parliament to call us. Let us give you our views. Thank God that it has been sent back to the ministry, and hope our views will be solicited. Otherwise, it has no place in a democratic dispensation.
Okay, well, social media has continuously been on the center of governance in this country, especially from the elections 2016, 2021, and we continue on to see it influencing a lot of things right now. It's been seen to be the voice for the voiceless. So when this does happen, isn't it going to infringe on the right of expression, the freedom of speech for the rest of, the countrymen?
It is going to infringe even more, because already it's been infringing in its current state. That's why you have people, having funny accounts that are not in their real names, for fear of being prosecuted. Okay, so with this current amendment, definitely the freedom of expression is going to be stifled even more. So you can't freely express yourself. You can't freely hold your leaders accountable.
Yeah.
You see, when all meaningful ways of dialogue are closed, what do you leave for the people? And that's when violence comes in. I mean, all meaningful ways of dialogue and debate has been closed. Media houses, in a way, have been also untwisted. There are certain people they don't invite. There are certain people they don't accept to be on panels. You get it? Political parties can't debate normally, okay? So what is left is social media, really, to hold people accountable, for people to hold their views, to share their views. And I think any reasonable government should not stifle that opportunity left, because that's when you could get feedback. Otherwise, if you can't get anything that's coming out from the people you are leading, chances are they are planning something very dangerous.
Okay. Councillor Musisi, with these limitations in terms of execution, how viable is this law for a country like Uganda, especially when it comes to the already suffocating judiciary? The case backlog is... Now, when we add all these things to judiciary, having to sort them out for us, where does this leave the judiciary?
Of course, it piles up and makes the problem worse because, like we've mentioned, we have so many unprosecuted cases where police charge and people are remanded. Some people could even be remanded without trial, many of them, and they are never prosecuted successfully. That means that you are piling up on cases without getting any convictions or acquittals. And of course, like earlier I mentioned that private disagreements, a disagreement between me and Allan should not be, I should not use the state to settle our grievances. This I can do it by taking him to court, to a civil court, where I hire a lawyer, he hires a lawyer, and settle it out there. But to use the state, the already depleted resources, the already depleted resources of the police, of the DPP, of the courts, I think it's taking us back. It's a clawback on all the gains we have achieved, and from a rights perspective, this is certainly a movement backwards.
Okay. Human rights activists, what are the people saying on ground?
People, of course, this is spelling doom for them, and they can't be any happy. But what I can assure Ugandans is that there is always hope. We'll try to engage government, we'll engage parliament specifically, and show them, you know, the harm in what is being brought. And because this will be used against them themselves. You've seen how Poma was used against the Honorable Mbabazi. Back in the days in the 60s, you saw how a certain law was used against Grace Bingira. So right now you are in the position that you can do make such laws. You can fall, you know, victim to such laws. So there is hope, but if it is passed in its current state, it's going to be disastrous.
Councillor Musisi, what should actually be the focal point of this Principal Act?
We all agree that social media may need some bit of regulation. We all agree that freedom of expression is not absolute. However, those exceptions that are done should be those which are allowed in a free and fair and democratic society. And like the Act has some progressive provisions. I think one of them is the issue of child pornography. It's a serious issue. And unfortunately, we have not even seen any conviction, let alone a prosecution, under that provision. And meanwhile, here we have an amendment making it more draconian when we have it. So the problem is not the law. The problem maybe is about investigation, is about enforcing. So we have a provision on child pornography in that Act, which is very good and is progressive and welcome. We have a provision on regarding data programs and stealing of software. That is progressive. However, when we come to these provisions which seek to limit, I think we need to expunge those provisions which limit freedom of expression, which limit usage, and instead we send them to people. If people feel they are demeaned, if people feel they are defamed, they can always go to civil courts and enforce their remedies after proving that others not using police to set our grievances.
And the question is, how do you prove it? Where do we draw the line on the offense that is being referred to? Well, it's a big conversation, and we'll continue to actually throw more spotlight on it to understand it better, especially the Principal Act and the fact that it actually covers some of these things. They're already existing. The problem is enforcement. The problem is actually bringing them to the end, and where it's supposed to have prosecution at the end of the subject. Away from that, we want to find out how people are actually responding to this conversation on ground. Ivan Kewanyolo is in Entebbe, and he wants to give us an idea of how people are actually responding to this in fear of anything they say, think, or do may be used against them.
Well, thank you very much, Chris and Priscilla. I am coming to you from the streets of Nkumba here, next to Nkumba University in Katavi Town Council, Wakiso District, this beautiful morning. Of course, people are busy moving out to go and find what to eat their families. The cars you're seeing behind me headed to Kampala. That means it's a busy day as usual, and people are moving out. But of course, I am on the street to just also engage the public. We know very well that the Kampala Central Member of Parliament, that's Muhammad tabled a bill to amend the Computer Misuse Act, and among them, of course, are those that attracts penalty to 7 years for those who, of course, will be found guilty in breaking the law. Nayenga tumanyi bulungi nti akachiko ka parliament akempuliziganya kakyalina ennaku 45 okubeera nti kekenenye ebbago lino okubeera nti liddamu okusomebwa eri parliament ate likubaganyizeeko ebirowoozo. Naye eno mu bantu ba wansi nabo balina kye balowooza kweri ebbago, era wano ku street badde njagala twogereko n'abantu batonotono nnyo nabo batuwulye kiki kye balowooza ku bbago omubaka wa Kampala Muhammad Nsereko lye yatadde wali yasomedde parliament ate eriri mu kakiiko ak'empuliziganya okubeera nti lyekennenyezebwa ku kozesa bubi omutimbagano. Njagala kuba nga njogerako n'abakulu batuwulye bano besinkanye ku street kiki kye balowooza ku bbago lino. Sebo nkwaliza ku NTV.
Nange nsanyusa.
Tuli ku bbago omubaka Muhammad Nsereko lye yasomedde parliament nakati tumanyi nti likyali mu kwekennenyebwa ennaku 45 okubeera nti akakiiko ak'ebyempuliziganya kalyekennenya. Kiki mulowooza mu abantu ba wansi ku lino ebbago?
Tulowoozako emirundi ebiri. One, nti ddungi on the other side, because abo bantu badde bakozesa bubi social medias okusanga nti oli ajja kukuwaako information etali ntuufu, asobola okwogerako information etali ntuufu, nti whereby gwe ng'omuntu kisazaamu reputation yo gy'obadde okumidde okumala ebbanga, ate nga olina okukuma ekifaananyi ekyo. On the other side, liyinza obutayita kubanga bo nga bo abakulembeze themselves are not even putting they are not in position okugoberera amateeka ago, be bavuma barwana, you know, in public. So bo banasobola
osasaanya obubaka ku muntu obusiga obukyayi oba nga temwebuzizaako oba ku mwana omuto nga teweebuziza ku bazadde be, ogwo gufuuke musango osibwe oba si ekyo weeyo engasi.
No, osobola okuwaayo endasi naye gusobola kuba musango, because one, tulina abaana abato abali innocent, toyinza kumala misusing rights zaabwe. Naye nga ku bantu abakulu kati wonna alwana nange nzije nkwebuuzeeko oba nkukube mu mawulire ng'omaze okweyisa
kati ngenda kuwandiikako kiki kyogamba ku nsonga eno.
Yes, nzije nkwebuuzeeko nti mukulu kiki oyagamba ku nsonga eno okuwandiikako oba nkuleke kubanga kati ndaba osusse. In other words, waliwo egasinga okukolera naddala ku baana abato, because we don't have to exploit their rights ng'abaana bato. Naye tekigenda kutuuka ng'abo bennyini abantu abakulu mu parliament waba nakkuba eŋŋumi olabye Otafiire. Actually there was a video ebadde circulating between Honorable Otafiire and another colleague. Amalemu amugamba, you repeat those words outside the chambers. I'm going to show you. So anamala gena mugamba kati Mr. Otafiire nkuwandiikako. Alinnya Kayanja Luusi Council wa district Nkumba.
Okay.